Welcome to Altea Talks, the brand new podcast series being brought to you by Altea, the unique provider of combined insurance and risk management solutions designed exclusively for the medical, allied health and care sectors. I'm going to be your host, Will Marshall, and I'll be joined in this series by some of the leading movers and shakers from across the sectors. My guests are going to include practitioners and professionals, regulators, clinical risk and governance specialists, and an array of legal experts who are going to help us get to the heart of the hottest topics affecting health and social care sectors today. So, if you're looking for frontline knowledge and expertise, if you want valued insights into these most dynamic, challenging and rewarding of sectors, then look no further because you're in the right place. Welcome again to Altea Talks. Hello and welcome to this latest episode of Altea Talks. I'm delighted today to be joined by Janet Keane. Janet is a director in the prestigious healthcare team based in DWF's offices in Dublin. Janet is a highly experienced and specialist clinical negligence solicitor with over 15 years' experience of defending GPs, consultants, and private hospitals. Janet has advised major defence insurance companies in numerous landmark cases up to and including Supreme Court jurisdiction. She works on behalf of leading global insurers and medical defence organisations in defending high-value and complex clinical claims. She also provides strategic risk management advice to her clients and their members. Janet is also a regulatory law specialist and has appeared on behalf of defence clients before the Fitness to Practice Committee of the Medical Council. She's also represented clients before the Mental Health Commission. In Janet's last post before joining DWF, she worked for a plaintiff firm, seeing the other side of the argument, and she was tasked with heading up the establishment of a nationally renowned branch of a medical negligence firm in her native Limerick city. This has provided Janet with a unique insight into what drives claims against health and care professionals in the Republic of Ireland. I'm delighted that Janet has taken time out of her busy schedule to join me today on Altea Talks. Janet, welcome.
Thank you, Will, and a warm welcome to Ireland.
Thank you very much. And I've been made to feel very welcome. I should say that we are broadcasting this from Dublin, and it's part of the support for the Altea launch of our European insurance service. So it's an absolute pleasure to be here and to be made to feel so welcome. So thank you for that. Janet, if I could start maybe with a very wide-ranging question, but I think for the benefit of people listening, it would be helpful if you could provide an overview of the healthcare system in the Republic of Ireland, including a little bit about its structure and how it is funded.
Thanks, Will. Well, so dealing with that question, it's possibly necessary to separate the question into two strands, dealing with healthcare law, which obviously I practice in, and then healthcare in practice. It is largely recognised that healthcare law is the one area of law that was never affected by economic crashes or cost of living crises. In fact, the number of outstanding clinical claims that are yet to be resolved stands at a record high in Ireland. The length of time to conclude a clinical negligence claim in Ireland compares pretty disastrously to other developed jurisdictions, on average about 4 years. So what this means from a defence perspective is that doctors in the Republic of Ireland are dragged through a fairly brutal process to the finality of a claim. I suppose this situation is one that I've worked in for many years, and you almost become accustomed to the outdated hoops that you have to jump through. However, it's only in recent months, actually, since joining DWF and working very closely with my UK-based colleagues, that it really has crystallised the archaic structures that we work within and the dire need for reform. So just in relation to the legal landscape, I believe the archaic structures and the delays stem from a failure to implement structured mechanisms to more speedily and efficiently advance claims. I'm not going to provide a history lesson that will no doubt bore your listeners, but if I could give one example, there are currently, despite there being statutory provision for periodic payment orders, they are not in place in the Irish courts. We have statutory provision. The Civil Liability Amendment Act of 2017 provided for their introduction, and this was widely welcomed by insurers, and they heralded their welcome, obviously not least because it avoided that upfront massive payment in relation to compensation for catastrophically injured patients. And in fact, plaintiffs, but the first periodic payment order was awarded in the Irish courts in February 2019. The sticking point, however, arose in relation to the real rate of return on investment. That had long stood at 3%. And in a seminal case in 2014, prior to the introduction of PPOs, Gill v. Russell, there was a consideration of this because the real rate of return was index linked to inflation rather than, as in the UK and other developed jurisdictions, where it's index linked to wages. Wages in the Republic of Ireland, especially at that time, had grown exponentially more so than inflation. Perhaps not currently, but certainly at that time. So when subsequent cases came to assess PPOs, they clearly stated that to abide by this PPO structure would mean that a plaintiff went severely undercompensated during the course of their lifetime, and no judge could preside over that. And so they're effectively a dead letter now in Irish legislation and certainly in the judicial system. And there needs to be statutory overhaul in relation to that. Similarly, we have no pre-action protocols, which is met sometimes with amazement by our UK counterparts.
Yeah, I was going to ask you about that because I do recall from my sort of brief experience of handling claims in Ireland or being involved in them rather than handling them, there wasn't the same degree of case management imposed by the courts that we see in healthcare litigation in the UK.
Well, I would say that's a kind assessment, Will, in relation to the structures that are existent here. There are no pre-action protocols, despite numerous claims, both from the judiciary in terms of reviews by repeated clinical judicial experts, but also perhaps more importantly, it has been accepted by government in their justice plans 2022 and 2023 as to the need for them. And more recently, prominent defence organisations have have published papers outlining the absolute need for their introduction. In addition, as you alluded to, there are no specialist dedicated clinical judges in place, despite there being highly experienced, eminent clinical experts sitting on the bench. And also there's no dedicated clinical negligence court lists. Instead, they are all piled in with the personal injuries list. And in relation to case management, while it is available on an ad hoc basis in exigent circumstances, it's not widely rolled out in respect of clinical negligence cases.
What's the impact of that in practice in terms of handling claims? So you've already mentioned they take longer to process. Are the legal costs inflated in your view as a result?
The legal costs, I think it has been fairly determined, are pretty inordinate in this country or exorbitant, and that has been accepted across the board. There has to be statutory impetus, but I do believe across the clinical negligence spectrum, be it plaintiff or defence, the introduction of these statutory necessities will be broadly welcomed because in essence, it's in no one's interest for these delayed processes to remain in place.
Yeah, and you're of course uniquely placed, well, not uniquely placed, but very well placed to take a view on that, having worked on both sides of the divide.
Absolutely. It exacerbates the stress and strain on individual practitioners, on insurers, and of course on plaintiffs who want finality. You know, it's not a bog standard trip and fall, if you don't mind me saying. These are stressful cases and they derive generally from not innocuous events. They are seminal events in people's lives. They don't take clinical negligence cases lightly, and practitioners don't take professional negligence cases against them lightly. So finality and a clearer pathway to a conclusion is always going to be welcome.
Yes, thank you. That's very interesting. And you've talked a bit about the healthcare legal system. Can we just sort of move it across to an overview of the healthcare system in Ireland and how that's structured, so that our listeners have a better idea of that?
Well, to deal with the challenges, they're probably similar to other jurisdictions that you will have encountered. Access, waiting times. Obviously, all of these have been exacerbated and magnified by the COVID pandemic. But in addition here, we have had repeated sporadic recruitment embargoes, one currently in place at the moment in relation to certain grades. We have an A&E crisis, which really is a podcast in and of itself, so possibly don't have the time to go into that, but most recently highlighted in my own locality in Limerick in relation to UHL. And we have an exodus of our post-qualification graduates in relation to doctors and nurses with regard to emigration. We have issues with regard to funneling of spending. We are a relatively wealthy country, yet in terms of comparative examples, CEO World Rankings of Health Systems ranked Ireland at 80. That is below a country like Albania. But if I could give where, the budget deficit would pertain there. But if I could give a better example, two countries where we'd have a similar pro capita spending, Austria and Denmark, lie at 3 and 4. Republic of Ireland lies at 80. The Republic of Ireland has the highest acute hospital bed occupancy in Europe. And we're the only Western European country without universal coverage for primary care. So there are a number, again, of issues which cause us to be an outlier. But I suppose dealing with the positive aspects and what can be looked at as laudable aims for the future, it would be remiss of me not to mention Sláinte Care. So Sláinte Care was launched in 2017 with the hope that it will be the revolution of the healthcare system, the public healthcare system in the Republic of Ireland. It's a 10-year programme, and its aims are to eliminate current two-tier health system that we have. Currently, almost 50% of the population hold private health insurance here. It aims to remove inpatient charges. It encompasses the expansion of primary care and the rollout of universal palliative care. Also, the disbandment effectively of the HSE with the creation of 6 regional health areas with their own budget. And I think the mission statement of Sláinte Care, when it was launched, sums it up quite succinctly. It seeks to achieve a healthcare system based on need rather than ability to pay. So the issue with Sláinte Care, having referred to its laudable aims, unfortunately, jettisoned into that period was COVID. And it had the impact of slowing everything down, possibly to a snail's pace, is the argument. It has been marred by high-profile resignations and general rollout in terms, for example, of digitalisation of the health service has been painfully slow. But the general consensus is that if the stakeholders involved have consensus of opinion and have a dedicated pattern and will to make this achievable, the aims of Sláinte Care will benefit society as a whole and the healthcare system in Ireland.
And so is that to increase the profile and reach of the public sector healthcare?
Exactly. As I say, it is based on a system whereby, I can't say it's modelled on the system of the NHS. I don't think that would be realistic given financial and budgetary constraints, but it is with regard to improving inordinate waiting times. For example, to see only yesterday I read people are waiting upwards of 2 years for MRI, with precedent being given to people in inpatient settings and obviously cancer patients. But that safety netting and the provision to catch health issues before they arise is obviously being missed with waiting times such as that. So Sláinte Care, that's one example of how the rollout is intended to benefit public patients.
Yes, I think that's interesting. It accords with really what's going on in the UK, or certainly the sort of wider aims in the UK, which is to focus more on prevention than cure, and to try and stop people from becoming sick in the first place, rather than having to deal with it at the other end of the process.
Absolutely. And something that struck me when preparing to meet you today was just harping back to COVID, some benefits can be taken from what happened, and the coexistence of the public and private sector and how they assisted each other in almost hard to believe harmonious ecosystem, and not trying to belittle everything that happened during COVID-19. But if benefits can be derived from what we witnessed and what we dealt with on an emergency basis, it is that balance to be struck, and how the systems can progress for one great aim ultimately, which is the improvement of patient care.
And it is interesting about how the public and independent sectors really do need to work together. It's the same story in the UK, where we've obviously got this sort of terrible waiting lists and so on, and post-pandemic, and increasingly the independent sector is being asked to pick up the slack with that and to provide capacity for NHS patients.
And obviously there has to be structured mechanisms and incentivizing factors for the private hospitals and private institutions to assist in the public. But if the private institutions can see a successful implementation and consensus of opinion in relation to the rollout of something like Sláinte Care, it will be an incentivizing factor for them to perhaps work more harmoniously.
And can I just ask, is there a state-backed indemnity scheme here for public sector hospitals, for patients who bring claims against public sector hospitals?
It's brought under the State Claims Agency, and the specific clinical element of that is the clinical indemnity scheme.
Right. So similar to the UK with CNST then.
Exactly.
Okay. And for the independent sector, are those hospitals and providers insured in the commercial insurance market or by defence organisations?
It would be a hybrid in relation to practitioners. There would be medical defence organisations and private commercial insurers, most likely with dedicated healthcare divisions within them. And the same would apply in relation to the commercial insurers for the private hospitals.
Thank you. That's really clear. Thank you. Can I just move the conversation on a little bit? I've obviously been reading up a bit in advance of today and have seen a lot in the press here about the cervical check scan, and particularly about Vicky Phelan and the 221 Plus group, and the introduction of the mandatory open disclosure policy in Ireland. Could you explain about the origins of the mandatory open disclosure policy, and let us know how the cervical check scandal influenced the implementation of that change?
Of course. So the headline campaigner for the introduction of mandatory open disclosure was, of course, the late Vicky Phelan, whose case and life are now tragically synonymous with the cervical check cases, but in the aftermath, her ongoing fight for mandatory open disclosure. By way of background, in 2011, Vicky Phelan had a smear reported as negative, but this was subsequently revealed as an incorrect reading. Vicky was diagnosed with cervical cancer in 2014, but was unaware until 2017, when unfortunately she received a terminal diagnosis that an audit had taken place, which included her 2011 smear, amongst other incorrect or misinterpreted readings. Vicky, however, was not informed of this audit at the time, with a dispute arising between Cervical Check, the screening provider, and her treating doctors as to who should disclose this information to the patients involved. This was the case, as you say, with varying factual circumstances for a further 221 plus women, many of whom tragically passed away from cervical cancer, including Vicky, who died in November 2022. But it is largely felt that her ongoing legacy is the incumbent introduction of the Patient Safety Act, which was passed into law in 2023.
Right, thank you. And what are the key provisions of that act, of that change to the law?
So the passing of the Patient Safety Act in 2023 replaces the old voluntary system, which was contained in Part 4 of the Civil Liability Amendment Act in 2017. So just dealing, I suppose, with Section 5, where a healthcare provider is satisfied that a notifiable incident has occurred, it shall hold a meeting in order to make open disclosure of the incident to the patient. Just emphasising the word shall, it's a mandatory provision, not a discretionary one. So what is a notifiable incident? There are 14 that are catered for currently within the legislation where open disclosure must be made. For example, wrong site surgery, medication error, unanticipated death during elective surgery, an unanticipated death of a pregnant woman, the unanticipated birth of a stillborn child or perinatal death, or for example, suicide of a patient within a health service setting. There's certain information that has to be disclosed at those open disclosure meetings, the date and description of the incident, when it came to the attention of the healthcare provider, the physical and psychological consequences for the patient, and the provision of an apology if and where appropriate. There's actually an extension of the notification requirements that are contained within the Patient Safety Act, and they will also have to notify external bodies. So HICWA, the Chief Inspector of Social Services, and the Mental Health Commission all now have expanded duties and quite unsurprisingly have called for additional resources and funding in order to carry out those expanded duties. Importantly, for insurers and health service providers, Section 10 provides that any open disclosure, including an apology, shall not invalidate insurance or constitute, for example, an admission of liability or be admissible as evidence in proceedings. A point of concern for insurers and healthcare providers was Section 77, which deals with non-compliance without reasonable excuse, which actually makes it a criminal offence not to make such open disclosure without reasonable excuse, with a fine up to and including €5,000.
So it's got teeth.
It's far-reaching.
It's far-reaching and it's got teeth. And how do you think this mandatory open disclosure policy is going to impact on the culture of the healthcare system? And for healthcare professionals, what will it mean in terms of ongoing and further training, risk management processes and initiatives, and upskilling?
Look, if I could focus on the word culture that you used, and I think that's crucial. The aim of this is for it to become embedded in the culture. I think that can only be done from on-the-ground training and from the ground up. There are guidances which have been published. For example, the National Open Disclosure Framework aims to set out a fairly consistent wide approach for health and social care services. And there is that framework extends to private health and social care providers. However, the relevant organisations will have to submit annual reports on open disclosure, its implementation and compliance with the framework. So I would suggest, and it would be my belief, that healthcare providers and healthcare practitioners need to take ownership of this issue, need to satisfy themselves that in advance there is specific on-the-ground training and not necessarily rely on the state rollout. There has to be, for example, face-to-face training, e-modules, ongoing renewed training, because there's going to be updated guidance on this. It's at its infancy. And as you say, Will, it needs to become embedded in the culture.
Yeah, it's got a lot of similarities with the duty of candour, the statutory duty of candour that was introduced in the UK in 2014. And that is of itself now undergoing a review by the government, because recent incidents have suggested that the duty of candour just isn't working properly. So it's not just an issue in Ireland. I know that this was very specific to the cervical screening cases that you've mentioned, but this whole being open seems to be a core principal requirement, really, of a healthcare service.
Well, I think the Irish system should be cognizant of any learnings that can be had from other jurisdictions. If there's any comfort to be derived for healthcare practitioners and their insurers, preliminary studies in other jurisdictions have indicated that there sometimes are a lessening of claims. Once mandatory open disclosure is in place, there isn't that information deficit for claimants and plaintiffs, and there isn't that lacuna that they need to overcome by way of civil litigation. That needs to be ironed out, and it needs to be assessed over a prolonged period of time, of course.
Yeah, of course. And you're absolutely right. I mean, if people think that they're getting their questions answered, they're having their concerns addressed, and they're actually being dealt with, that must, it seems as a matter of logic, reduce the likelihood of a claim further down the track. But as you say, it's in its infancy, and it seems that there's going to be a lot of learning for healthcare providers in Ireland, and a big opportunity, it seems to me, for insurers and brokers and so on to really help their clients with the introduction of this sort of fundamental cultural change.
To be able to avail of that advisory service, if it were available to healthcare practitioners and institutions, I think would be absolutely invaluable in what is a new system. I don't think anyone expects a utopian introduction for all healthcare providers to know exactly what is a notifiable incident. Talk to your legal representatives, talk to your insurers. They are also charged with advising individuals and organisations correctly. And it is in everyone's interest to be able to navigate this new legislation as best as they can.
Thank you. And moving on, it would be really helpful if we could just take a look at a couple of specific sectors, a couple of the niche markets that are maybe not at the center of healthcare, but which are incredibly important and are used by numerous people up and down the country. And the first one I'd like to focus on is the aesthetics sector, because I know that there has been some adverse publicity about patient safety issues or client safety issues within that sector. And I thought it would be really helpful, Janet, if you could provide a bit of an overview about what the current regulations are governing non-surgical aesthetic procedures in the ROI, and how you feel that these regulations are helping to ensure the safety and quality of the treatments that are being provided to the public.
As you said, Will, this is an area of hot debate in really what is an emerging and booming market. Obviously, a distinction needs to be drawn, as you said, between surgical aesthetics and non-surgical aesthetics. So we're not talking about cosmetic procedures involving medical doctors or nursing staff within that setting, which are obviously governed under the Medical Protection Act of 2007 or the NMBI. So we're not talking about breast augmentation, rhinoplasty, gastric surgery. What we are talking about is the non-surgical aesthetics. Certain medical devices are captured under the Health Products Regulatory Authority or the European Medicines Agency. That might include restrictions on who can prescribe and administer such devices, like laser hair removal machines or skin tightening apparatus. The HPRA can apply monitoring of safety devices. I think there's a national reporting system and actions such as safety notice recalls. But really, Will, dealing with the elephant in the room, in terms of the significant emergence of non-surgical aesthetics, there is currently no regulation for non-healthcare practitioners providing dermal fillers, laser hair removal, chemical peels, microneedling, and Botox, to name but a few. But in terms of the risk management, the avoidance, and dealing with the current status quo as practitioners have to deal with, it's hard to overemphasize, given the lack of regulation, the importance of risk management to these practitioners and providers. These risk assessments must be tailored to the services that they are providing. Regardless of the lack of regulation, there are non-delegable duties that they have under the Safety, Health and Welfare at Work Act 2005, for example. But in addition, I would say a baseline, to answer your question, a baseline risk assessment should comprise and cover and I'm open to correction from the experts on this, property and treatment hazards, areas of risk that need addressing, the importance of health and safety observance. And again, just going back, if they were to liaise with their insurance providers, they might be able to assist them. Is there compliance software that they can integrate into their system? But overall responsibility of this does rest with the clinic owner. And separating out the potential areas or the timeline of a risk assessment, identify the hazards. Are they on the premises? Are they in relation to products? What are the physical risks? Can there be overt warning labels? Decide who is at risk and how. Is it a contractor on the premises? Is it an employee or is it a customer? Identify the types of injuries that they are potentially exposed to and evaluate the risks and take action. Perhaps newer safety equipment, upskilling staff, avoiding harmful chemicals, safety netting advice, before and after photos with consent. For example, if you're undergoing laser hair removal, does the customer use Roaccutane, which is contraindicated in respect of laser hair removal? Have they had recent exposure to sunbeds, the fake variety, or sun exposure? Basic components, but critical ones, and ones that you will be asked by your insurer in the event of an adverse incident. Record your findings. Use and review the assessment. Pin the risk assessment to your wall in a prominent place. And what I would say is any such risk assessment, as detailed as they are probably futile if they're not updated and carried out regularly. Update when necessary or on foot of new guidance, on foot of adverse events, or at the very least, I would say once a year. But again, I'm open to correction on that.
Yeah, thank you. That's all very sensible, practical advice. Can I just ask, Janet, what are the most common types of legal claims that you see in Ireland in this sector?
The types of injury and their severity can differ. However, more commonplace injuries sustained would be, for example, burns and scalds, allergic reactions, skin reactions, piercing wounds, inflammation, infection. And in terms of the type of claim brought, this can vary between personal injury claims, product liability claims, or depending on the practitioner, sometimes clinical negligence claims, but not necessarily in the non-surgical setting, or it could be a hybrid of those type of claims.
And to what extent is consent or an alleged failure to obtain consent an element of claims in the sector?
It will form a basis, again, on the non-surgical setting. You're not coming at it from the clinical negligence perspective in relation to informed consent, but it does play a critical role nonetheless in relation to what a customer is coming in and consenting to with regard to any procedure carried out on them that has the effect or has the potential risk of the injuries that we just outlined.
Yeah, thank you. Thank you. Moving on, I mentioned at the top that you're also a regulatory lawyer. Can you explain a little bit for the listeners about the role and responsibilities of CORU? Am I pronouncing that right? CORU?
Sure, indeed.
Yeah, CORU, the Irish regulator in the Irish healthcare system, and how that seeks to ensure the competence and professionalism of practitioners.
Certainly, yeah. CORU govern the regulation of health and social care professionals. So that would include physiotherapists, optometrists, dispensing opticians, occupational therapists, speech and language therapists, and social care workers. And obviously these cohort of health and life science practitioners have their own independent bodies as well who seek to promote and protect their interests. So CORU have statutory responsibility for establishing and maintaining a register of members of the profession, assessing, approving and monitoring training courses that are provided under the legislation, the Health and Social Care Professionals Act of 2005, and establishing a code of professional conduct and ethics. And they also are charged with conducting disciplinary investigations when and where necessary in relation to both professional competence and conduct.
Yes, thank you. And I understand that a number of new professions are expected to be added to CORU's regulatory remit.
That's right. And this is to be welcomed. It will extend, it is believed to be imminent in relation to clinical biochemists, counsellors, orthoptists, psychologists and psychotherapists.
It's a single regulator for all of those
Absolutely,
professions.
Yeah.
And why is continuous training and professional development essential for the health and care professionals who are regulated by CORU? And how, in your view, does that contribute to help them maintain high standards of patient care and safety?
Well, a lot of health science and social care practitioners work in clinical and non-clinical settings, but their work is critical and it's life-enhancing. They augment the medical work, and their participation in improving patient and societal outcomes is actually immeasurable. Well, ongoing training and risk management assists this by way of ongoing and updated developments, trends and research. It also serves to protect these frontline professions by keeping their own skills up to date.
Yeah, thank you. And just the last niche area that I just wanted to touch on was the care sector, and particularly nursing and residential care homes. And I just wanted to ask you what you think is likely to be the impact of the COVID-19 inquiry on nursing and residential homes in Ireland, because I understand that inquiry has not yet taken place or not yet reported.
Correct. And really topical. I suppose the strain and invaluable services that nursing homes and residential homes provide was really magnified by the COVID-19 crisis, not just in Ireland, but worldwide. A COVID-19 inquiry is to be established. All indications are that it will be a non-statutory, no-blame inquiry with a focus on hospitals and residential home settings. As I understand it, draft terms of reference have been circulated to Cabinet and it is expected to be made available to the public soon. Just focusing on the fact that it's a non-statutory inquiry and the impact of that, this non-statutory inquiries are commissioned by the Minister as deemed matters of public importance. It does not entitle witnesses to the same immunities and privileges as a statutory inquiry, and it does rely on voluntary contribution. Witnesses aren't necessarily entitled to immunities from suit. So following on from that, what I would say is careful consideration must be given to all evidence disclosed. In terms of documentation management, which really will be critical here, preserve the preservation of any documents seen as relevant, and to make sure, for example, that they're not destroyed inadvertently. Relevant documents need to be organised, collated, reviewed by both of the organisations, their insurers and their legal representatives to ensure familiarity, to decide on what's disclosable and what isn't once the terms of reference are published. Consider GDPR and data protection issues. Liaise with your data protection officer, again, perhaps in conjunction with your insurer, with regard to any concerns that you might harbour as to whether a document is relevant or not. And it goes without saying, healthcare documents are the most sensitive of documents. So really a 360-degree review of the legal implications of discovering and disclosing documents will be essential here.
Yeah, absolutely. And moving away from the COVID-19 inquiry to look at that sector a little bit more widely, what are the most common types of legal claims that you see brought against nursing and residential care homes in Ireland, and what underlying issues typically lead to these claims in your experience?
So it might be useful just to separate out perhaps claims brought by service users versus claims brought by members of staff. In terms of service users, very prominent claims would be, for example, medication errors. And the bases for such claims, for example, might be where there's the absence of strict dispensing policies. For example, where one person is charged with checking the medication, but also dispensing it. There isn't that catch-all person, an independent, who might prevent a medication error in its tracks. Then in relation to negligent care, this can come under many guises, but obviously we're dealing with the most vulnerable cohort of individuals. There might be very specific devised care plans which need strict observance. even the interpretation of those care plans. For example, there's a large cohort of foreign staff and language difficulties sometimes pertain. But staffing issues, aren't an adequate defence to these claims, and there must be policies and preventative measures in place if these, for example, language difficulties pertain. There is also personal injury with regard to the use of hoists for particularly immobile patients. And the importance really of risk management in this area cannot be overemphasized. When it comes to staffing and perhaps employer liability claims, you might be looking at stress and burnout in what is a pressurized environment. And I'd just like to pay particular attention to care managers who are charged with coordinating all of these policies. They must be assisted and the resources must be made available to them to have the correct systems in place to oversee all of the correct implementation of policies, to assist with these structured pathways for everyone to navigate.
Some access to some sort of specialist HR function, I think, is, if it's possible, and I appreciate it's not always possible at the smaller end of the scale, but I think that is absolutely essential to manage some of those employer liability risks.
Absolutely. In terms of staff, like you said, structured HR facilities, I believe, are crucial to address and prevent staff stress. A lot of this are about preventative measures and burnout. Clear pathways for staff to navigate. And one other area, for example, would be reporting structures for any concerns harboured by staff or service users in relation to other members of staff or indeed service users. Dealing with sensitive matters like service user alcohol dependence or interpersonal relationships within that setting. And one area perhaps we haven't touched on is violence-based claims and specialist risk management training, for example, to know how to de-escalate an adverse event, and the safe and lawful use of restraint, which is, of course, sometimes necessary in this setting.
Yes, of course. So it sounds like they're some very similar themes and issues affecting the sector in Ireland as in the UK. But I agree with you that risk management is absolutely key to managing those risks. I just wanted to move it on and just talk about a feature of the Irish law that is completely novel to me, I must say, about the 1% rule and concurrent liability. And I was hoping that you might be able to explain for my benefit the significance of the 1% rule on joint defendants in the Irish legal system and how that influences allocation of liability and compensation in cases involving multiple defendants.
Well, to sum this provision up in a fairly difficult nutshell, for a piece of legislation over 60 years old, this provision remains tricky and troublesome for plaintiffs, defendants, and insurers alike. But to do my best, what concurrent liability, or the 1% rule, refers to is that under Part 3 of the Civil Liability Act of 1961, where two or more parties are responsible to a third party, so the plaintiff, for the same injury or damage, then they are concurrent wrongdoers. And the plaintiff can execute the whole award against either or both of them. So far, so good. But where the colloquial term, the 1% rule, comes into play is even if you, as a concurrent wrongdoer, are found to just be 1% liable, the plaintiff can look to you for 100% of the award. So this provision gained sharp focus during the 2008 economic crash, the IMF bailout, which ensued, with commercial cases where there were multiple defendants. And when these trials came to fruition, a lot of the defendants had actually gone into liquidation. In the healthcare context, we see this arising in a situation where, for example, we see this on a daily basis, a scattergun approach to a case whereby a plaintiff sues the treating clinician, doctor, GP, consultant, who have their own professional indemnity insurance, but they also sue the practice or the clinic or the owners of the practice. The issue with concurrent wrongdoers can prove difficult in these scenarios. So, for example, if the clinician, for example, has not abided by their policy cover and cover is not extended to them, or indeed if there's a systems issue at place and the clinic goes into liquidation, the 1% rule can affect the other named defendant in the event of an award. So I suppose it is a reminder to practitioners to always consider your client's case from first principles, to identify the best arguments and to vigorously pursue them.
Yeah, thank you. And I just wanted to touch on one other specialist area, which I know is one of your areas of expertise, and that's with regards to inquests and the coroner's service. As I understand it, again, there are proposed reforms of the coroner's service in the Republic of Ireland. And I was hoping that you might be able to tell us a little bit about how these are likely to impact on the conduct and outcomes of inquests, and what the changes will mean to the way that healthcare providers prepare for inquests and the significance of inquests.
So like the UK, the inquisitorial nature of the inquest process has been reaffirmed repeatedly by the courts. However, as practitioners, as we are all too aware, the process can turn into a quasi-judicial setting with fairly robust adversarial cross-examination, if allowed, in particular in relation to different coroners' approaches. It goes without saying that nothing can compare to the stress and the anguish for families in this process. But I do think consideration must also be given to the other witnesses called in the context of healthcare providers, sometimes some of whom are absolutely peripheral to the care that has been provided in what is a really heated setting. Reforms have long been suggested to this old coronial process, and steps as recently as last year have included a public consultation service seeking input in relation to the future structure of the service, and the Department of Justice establishing an advisory committee to gather perspectives from various stakeholders to support this consultation process. So from that, the committee has made initial recommendations, creating more streamlined rules relating to verdicts to ensure nationwide consistency, and a central database which isn't currently in existence to record all recommendations made. Further calls have been made, which I believe is in place in the UK, for pre-inquest reviews to outline plans for the inquest. The full implementation has been called for Section 19 of the Coroner's Amendment Act of 2019, which with regard to recommendations to be made with a view to preventing future deaths, notifications in relation to prevention of future death.
Do you have that system currently where if the coroner has concerns about potential harm, they can issue a report to all interested parties seeking prevention of future deaths report?
It's not catered for currently, but it is certainly in the recommendations. A verdict of medical misadventure would be the go-to verdict in that event, if so deemed. In addition, I suppose reforms centre on data collection to assist ongoing learning. And of particular importance to grieving families is a preliminary explanation as to the process. It's a very daunting setting and scenario, in particular if families aren't represented. And I think that is something that would be welcomed by in all quarters.
Can I ask, Janet, if there's an inquest and it does lead to a claim for damages, are the costs of legal representation in the inquest recoverable in the subsequent claim by the family?
They can be claimed within the context of a civil litigation fatal injury claim, but not as a de novo representation within the context of the inquest itself.
Yeah.
Which is often a bone of contention for families, because for some, they put the inquest and the verdict in their own minds in terms of their own priorities ahead of a civil claim to actually understand what happened to their loved one. Within fatal cases, what is recoverable in the Republic of Ireland is a solatium fee. So this is the figure to be shared by the next of kin and is a finite figure currently standing at €35,000. You also have funeral related expenses, financial loss, which will vary depending on the deceased. For example, domiciliary services they may have provided, childcare services. And then, as you say, legal representation at an inquest within the context of that civil claim.
Yeah. So much to talk about. And thank you for sharing benefits of your wisdom on all of those areas. I am extremely grateful. It's been very clear. But I thought we'd just finish up by maybe touching on your experience of working for a plaintiff firm and the insight that has given you into the clinical negligence world, and what you think are the most valuable risk management lessons that can be applied to mitigate or, heaven forbid, even prevent legal claims arising from medical mismanagement.
Well, to plagiarize a quote often recited by an old employer of mine, medicine is a science of uncertainty and an art of probability. I was surprised when I entered. 15 years I practiced in the defence industry with 2 in the plaintiff world. So I will preface that. What surprised me the most was actually the motivation of plaintiffs, why they came knocking on our door. Very rarely actually was money discussed. Was there any monetary compensation? It was generally the case that they wanted to know what happened. They were in the dark. There was an information deficit. They needed to know why this occurred to themselves or their loved ones. They wanted knowledge that learnings will lead to better services and outcomes. They wanted robust and transparent investigations. If I could give you one anecdote, there was a lovely family who I represented. Were very much at the preliminary stage of investigating and attempting to gather an independent report to comment as to whether there was liability related to this family's father. Passed away during the COVID-19 pandemic in a hospital setting. And they had severe reservations over the care that he received and whether it contributed to his death. And we received an independent report, and it was unsupportive in relation to liability. I was very tentative about relaying the contents, nervous even about relaying the contents of this report to them. They had expended a lot of money on it in order to assess this. But I set them all around the table and I did read it out to them, and I asked them to read it independent of me. And then I came down and spoke to them. And the overwhelming reaction was one of relief. And they left that room, of course, I wouldn't say the word happy, but with a sense of relief that the fears that they had harbored in relation to the care that their dad received proved not to be the case. He did receive excellent care. And the reaction really surprised me. I don't believe that patients or plaintiffs want a utopian service, nor is it the legal standard, nor can it ever be achieved. What they do want, I suppose, is avoidable mistakes to be catered for, systems to be in place that don't hamper the care that the clinicians provide, nursing and doctors. They want a modernization of the archaic system that we referred to. For example, if records were made available in a more timely fashion, it can take up to 6-7 months in this country to access medical records, depending on what institution you seek them from. If they were to be made available in a timely fashion, it would avoid speculative claims being launched in order to defeat the statute of limitations with the concomitant costs that involves. So that is my perspective from there's a myriad of issues that we can discuss from my experience in the plaintiff field. But I would just emphasize the fact that within the legal healthcare field, within the health practitioners, we have excellent people. We just need the systems around them to complement what they do, to assist them and to help it grow.
Yeah, thank you. And it's very interesting the way that almost brings us back full circle and highlights the importance of the mandatory disclosure legislation that's coming in, highlights the importance of being open and highlights the importance of responding to complaints, responding to requests for clarification in a timely, effective, open and fair manner.
I couldn't agree more. And where there is any confusion, obviously this is a new system, this is a new rollout, seek advice, ask the questions. The information is there, the experts are there in various fields to assist in what can seem like a winding road in front of practitioners, but the help is there to assist them.
Janet, thank you so much. That's been a really fascinating and enlightening whistle-stop tour of all things healthcare and legal in the Republic of Ireland. I'm incredibly grateful to you for your time and for providing such an insightful and riveting account of the world that you're working in.
You're very welcome, Will.
Thank you for tuning in. I hope you enjoyed today's episode of Altair Talks. If you did, please don't forget to subscribe or leave a like or a review on whatever platform you're listening on, as this helps spread the word. If you have any questions or comments or topics you'd like us to explore in future episodes, please do contact us, as we'd love to hear from you. You can find us on LinkedIn or visit our website at www.altairinsurance.com. Stay tuned for more episodes, and until next time, take care of yourselves. The information contained in this podcast is not intended to represent a complete analysis of the topics presented and is provided for information purposes only. It is not intended as legal advice, and no responsibility can be accepted by Altair Insurance or DWF Group for any reliance placed upon it. Independent legal advice should always be obtained before applying any information to particular circumstances.